everyone. Today we want to spend just a little bit of time with you going over the requirements within Section 1557 of the Affordable Care Act. So, first of all, what is Section 1557? Well, it's the portion of the Affordable Care Act that deals with non-discrimination law. And it's important to achieving the Affordable Care Act's goals of expanding access to health care and coverage, eliminating barriers, and reducing health disparities. Specifically, it prohibits discrimination on the basis of race, color, origin, sex, age, or disability. And it builds upon long-standing non-discrimination laws and provides new civil rights protections. That said, it is a part of the Affordable Care Act. As we know, there has been some activity within the administration to potentially repeal or take away pieces of that. So far, with the way that they are potentially going to do that, this is a section of the Affordable Care Act that would not be touched. So it's important that we are all following these guidelines and requirements of Section 1557. So let's dig into it a little bit more about each of those specific requirements. So we know that it prohibits discrimination based on individuals' race, color, or national origin. Specifically, it says that a covered entity, so us as a provider, may not segregate, delay, or deny services or benefits based on an individual's race, color, or national origin. So I can't assign a patient to a patient room based on their race. I can't require a mother to disclose her citizenship or immigration status when she applies for health services for her child. It also says that I can't delay or deny effective language assistance services to individuals with limited English proficiency. You'll see that acronym LEP. Okay? Section 1557 protects individuals in the United States, whether lawfully or not, who experience discrimination based on any of Section 1557's prohibited basis. So you will see that we actually have a specific way for our patients to file a grievance if they would feel that they were being discriminated against. It does require that we have ways for communicating with our LEP individuals. So it says that we have to take reasonable steps to provide meaningful access to each individual with LEP eligible services. So reasonable steps may include providing language assistance services. That could be written translation. That could be an interpreter. It also says that we have to publish taglines, which is a short statement in the languages that are spoken by our patients, our clients, in the significant publications we use, and that we have it posted on our website as well in our departments, in our waiting areas, in a very visual spots or somewhere that they are going to see that information. And what those taglines say is, in their language, it's going to let them know that we have the availability of language assistance services. We have to offer qualified interpreters, and when language services are required, we have to provide those free of charge, and they have to be provided in a timely manner. So let's talk about that a little bit more when we talk about a qualified interpreter. There are quality standards in delivering language assistance services that we have to make sure that we meet. We cannot require an individual to provide his or her own interpreter. Again, we have to do that free of charge to them, and it has to be timely. We cannot rely on their children to interpret for us, except if it would be a life-threatening emergency when we just don't have anyone immediately available. Most likely in therapy, that would not be something that would happen, right? We know when these patients are coming in, we would have that interpreter already scheduled ahead of time to come in to provide those services. We cannot rely on interpreters that the individual prefers when we are questioning competency, confidentiality, or we have other concerns. We cannot rely on unqualified bilingual or multilingual staff, and we can't use low-quality video remote interpreting services. So Section 1557 also prohibits discrimination based on an individual's sex. So it essentially says that we have to provide equal access to health care, health insurance, and other health programs without discrimination based on sex, including pregnancy, gender identity, or sex stereotypes. We have to treat individuals consistent with their gender identity, including with respect to access to facilities such as bathrooms and patient rooms. We cannot deny or limit sex-specific healthcare services based solely on the fact that the gender identity or gender recorded for an individual doesn't align with the sex of the individual who usually receives those types of services. Okay. And then sex-specific programs are allowed only if a covered entity can show an exceedingly persuasive justification for the program. That means the sex-specific nature of the program must be substantially related to an important health-related or scientific objective. So they give a good example here that if we have a breast cancer program, we can't refuse to treat men, solely because it would make our female patients uncomfortable. So things from a therapy perspective we may think about our continence programs or our pelvic pain programs. Sometimes what you would see historically is those referred to as a women's health program. Well, men can have those issues as well as women. So it would be something really that we have to think about how we label those programs, as well as making sure that we are including everyone that could be having those issues, knowing that it is not gender specific. Section 1557 also prohibits discrimination based on an individual's age. It says that we may not exclude, deny, or limit benefits based on age. Okay. So we can't say that our practice, we only accept patients under the age of 60. Now we do know that we have some things that we have some specialty areas, and you can see here that they give the example of a pediatrician would not be required to treat adults and gerontologists, right? So we know we do have specific pediatric programming, okay? That we, our birth to 3 program, obviously that is for birth to 3. We're not going to allow somebody else to be treated within that program. But for our general clinics that are not in a specialty area, we cannot prohibit care based on the age of the client. Section 1557 prohibits discrimination based on disability. So this one for us as therapists really probably seems like okay, exactly. We treat people with disabilities all the time, right? That is our clientele. But we want to make sure that we are following all the regulations and thinking very broad about that definition of disability. So it says that we must take the following steps unless they would result in an undue financial burden or alter our program. We have to make reasonable changes to our policies, procedures, and practices where necessary to provide equal access for individuals with disabilities. So, example, if a clinic had a no pet policy and we have an individual with a disability who is accompanied by a service animal, we would need to adjust our policies, procedures, and practices for that. If we have a patient who has an anxiety disorder, we need to make adequate spots for them available where they maybe need to, wait for their appointment in a separate quiet room if our waiting room is causing them some issues. We don't currently do this, but if we required people to make appointments online, we would have to make sure that our people with disability have the ability to do that electronically, that we've thought through that process so that it's easily accessible to all individuals. We, of course, need to make sure that we are physically accessible with our facilities and provide effective communication. So that brings us to talking about auxiliary aids and services. There may be things that our patients need in order for them to be able to fully participate with us in their program. And just like we talked about the issue if somebody doesn't have English as their primary language, what we do for them. Maybe somebody has a disability that requires this auxiliary aid. So this could be a sign language interpreter, providing large print materials. Maybe we are using a text telephone, using captioning. Maybe we have to get creative with how we talk to someone about their exercise program or show them their exercise program and some different things. Again, we can't require the individual to provide their own interpreter. Okay, so if this is somebody with a hearing impairment that would need a sign language interpreter, they can't be required to provide their own. We cannot rely on a minor child. We cannot rely on the interpreter that the individual prefers if we think there's a competency or confidentiality issues. We can't rely on unqualified staff. And again, we need to make sure that we've got, if we're doing something through video for interpreter services, that we do have a high quality to that video. So your responsibilities are a few different things that you need to make sure of. First of all, we've got some policies and procedures around Section 1557 requirements. They're related to non-discrimination, LEP, auxiliary aids, and grievance. So you want to familiarize yourself with these policies and procedures. We have sent you all, we sent it back in the fall, and then we sent just recently a prettier version of it, which is the non-discrimination statement and our language taglines all on one page. So that needs to be in a waiting area or other conspicuous place at your physical location. We do have that on our website. And if we had some significant publications or vital documents that we would maybe be sending out as marketing material, that type of thing, we would need to make sure that this information is included with that as well. You have to post our notice of accessibility as well. Make sure that when you have a client that comes in that needs something, that you have a way to access what they need. So really work within your team to develop and utilize a language access plan, which maybe, initially is determining their primary language. Make sure that you have up front some options, that you have some telephonic oral interpretation. Maybe you keep those numbers posted in case this arises. You're not having to scramble to get that. Find out what the services are in your area and have that information ready in case you need to call. Also look to see if there's any documents that you think we need written translation, as well as beyond written translation. Is there something we need to be doing in large type or some other format for some of your patients that need some accommodations to be successful within their program?